Welcome to our 650 webinar today, Federal Emergency Temporary Standards for Employers with 100 or more employees. For those of you who may not be familiar with 650, we are the legal technology subsidiary of the law firm Wilson Sonsini, and we take world-class legal expertise and combine it with thoughtful technology to make the law more accessible for businesses and individuals. One of the reasons we're giving this seminar is we've been working hard to help businesses to comply with the requirements of the new federal emergency temporary standards. And we're going to share some of the things we've learned about the standards as we've been helping businesses and creating tools regarding the emergency temporary standards. My name is Ryan Parker. I'm the Chief Legal Product Officer here at 650. And with me on the webinar today, I have three of my colleagues. We'll start with Marie Colbeth. Marie graduated from one of the top law schools in the country, clerked on the Fifth Circuit Court of Appeals, and we'll hear more about the Fifth Circuit later in our webinar today. She then worked for a university before joining us at 650. Marie wears a lot of hats at 650. She's our general counsel. She's also a vice president of legal product. Marie is instrumental in our privacy practice and helps customers to comply with the CCPA, which is turning into the CPRA, GDPR, PIPL, and all the different privacy needs. She's helped to design and continues to help update our privacy products, along with helping us on a number of different employment products. Next, we have Adrienne Jack, who went to one of the top law schools in the country before working for a large Washington, D.C. law firm. She joined us a little over a year ago and was instrumental in creating our employee handbook tool, which was a big job, and it's been an amazing tool. Adrienne also is probably the most knowledgeable member of our team when it comes to Cal OSHA. She helped to develop our Cal OSHA compliance tool. And finally, we have Adam Wright. Adam Wright went to the University of Michigan Law School, go blue, and then clerked for 2 federal judges in North Carolina. He worked at several law firms before joining us here at 650, and he's recently been heading up our employment agreements, our new employment agreements project, helping to create a document engine that can create offer letters and employment contracts for employees in all 50 states and the District of Columbia. So I'm really grateful to have this great group of attorneys to help talk to us about the federal ETS. There's a lot to talk about. Before we dive into the agenda, let me just take care of a couple of housekeeping items. One, we know that there will probably be a lot of questions. We'd ask that you use the Q&A button at the bottom of your screen so that we can track and answer those. It's much easier than the chat function. So please use the Q&A. And finally, I'll just mention a couple of other things. One, we will send out a video presentation of this webinar along with the slides. So you don't need to ask for those. Those will be sent to you automatically in a follow-up email. This webinar is also eligible for CLE, and so we'll be giving a CLE code in the middle of the webinar. So make sure you pay attention and you write down that CLE code. Finally, I'll just mention that the emergency temporary standards and the vaccine requirement have become hot button political issues, and we're going to try to avoid the political parts of those issues and just give you sort of the straightforward information about the ETS without a lot of editorializing, and we'd ask you to sort of steer away also from the political parts of this issue to the extent that that's possible. With that, let me jump into our agenda for today. I'm going to start by talking about the litigation and legal challenges. This is my favorite area. I spent 10 years at the Department of Justice and then served as the chief of litigation at the Office of the Director of National Intelligence. And so when I see government programs being challenged in court, it gets my blood pumping, and it's something that I am passionate about. And so I'll talk to you about the legal challenges that we've already had to the ETS. It's a very interesting area. From there, we'll move on to state OSHA plans. And this is a complicated issue that can affect a lot of different businesses, and whether they're subject to the federal ETS or subject to the state OSHA plans. We'll then move on to the employee headcount. As I mentioned earlier, the federal ETS applies to employers with over 100 employees, but there are a lot of nuances to how you count those 100 employees. Then we'll move on to the written plan requirement. We'll talk directly about the vaccination and test mandate, and then we'll dive into some of the other requirements that are less familiar to many people that are in the ETS. And so we'll kind of switch off and different people will present these topics. If you have questions about them, put them in the Q&A. We may answer them as we go. We'll answer some through typing, we'll answer some live, and we'll have a Q&A session at the end of the webinar. With that, let's jump into the litigation. Well, let's start with what are the ETS. I want to make sure we have a good foundation as we talk about the federal ETS. So what does ETS mean? ETS means Emergency Temporary Standards. And this ETS that we're going to talk about today, the federal ETS, were issued by the Occupational Safety and Health Administration, otherwise known as OSHA, on November 5th, 2021. So they are only 5 days old, but they have already engendered a lot of litigation. I will say that they were published in the Federal Register, and I provided a link that you'll get in your slides. And the ETS are 154 pages long, and those are those great pages that you get in the Federal Register that are not only single space, but have 3 columns. So there's a lot there. We spent a lot of time reading through them, trying to decipher what they mean, and we'll present a lot of that to you today. But there's a lot to go over when it comes to the ETS. Finally, the thing that we have that has drawn the most attention with the federal ETS is that employers with at least 100 employees must adopt a vaccination policy that requires employees to be fully vaccinated or submit to at least weekly COVID-19 testing. And that's really kind of at the heart of the ETS and the issue that we'll spend the most time on today, and certainly the one that has drawn the most attention. So with that, now that you have sort of a foundation of what the ETS is, let's dive in. The ETS were initially announced by President Biden several months ago, and he announced that the ETS would be forthcoming and that OSHA was formulating them, and they have already led to significant litigation. In fact, a month ago, before the ETS had even been issued, the Attorney General of Arizona, Mark Brnovich, hurried to federal court to file the first suit before the ETS were even issued. And Attorney General Brnovich is also running for a Senate seat in Arizona, and he sort of used that as an opportunity to express his displeasure with President Biden's announcement. And I think it was an indication of how this litigation was going to be politicized. When the text of the ETS was actually released, and that was on November 5th, suits were quickly filed by 26 states and various private employers in the U.S. Courts of Appeals for the 5th Circuit, the 7th Circuit, the 6th Circuit, the 7th Circuit, the 8th Circuit, the 11th Circuit, and the DC Circuit. And because of the review provisions in the OSHA Act, those could be filed directly in the Courts of Appeals. They did not have to go to the federal district court. And for those of you that may not be familiar, fully familiar with the court system, you have the federal district courts, which are the trial courts. You have the federal circuit courts, which are courts of appeal. And right above that, you have the Supreme Court. And so these were filed directly in the courts of appeals. On November 6th, the 5th Circuit, which is where my colleague Marie Colbeth clerked, and a circuit that is widely considered to be the most conservative of all the circuits, issued a stay of the ETS pending expedited review on the merits, meaning that the ETS cannot take effect until that stay is lifted. And so right away, one of the courts has weighed in and has stayed the application of the ETS. Let's move to the next slide. So the interesting thing here is that because these suits were brought in so many different circuits, the Department of Justice notified something called the Judicial Panel on Multi-District Litigation. And this is something that doesn't happen all that often. But what it means is when you have a number of different suits that raise the same legal issues that are filed in district courts or circuit courts across the country, they can all be consolidated into one suit. They are then assigned to one circuit court that's chosen by lottery. And in this case, they will be heard by a panel of 7 circuit and district court judges from different circuits. And so you'll get a panel of judges from across the country, a panel of 7, that will hear these consolidated cases. They'll hear all the arguments from the different parties and decide the cases because of the similar issues that are presented in so many of the different cases. the Department of Justice has informed the different courts of appeals that have cases that it expects the multi-circuit lottery to take place on or about November 6th. So in a little less than a week, we should know which circuit will have this consolidated case with all these different arguments from the different parties. The interesting thing about the challenges is that they're brought by a number of different types of organizations, 26 different states, private employers, and brought in courts across the country, but many of them raise the exact same issues. And so the big question that I think a lot of businesses have is, will the suits challenging the ETS be successful? And I'm going to give you a very lawyerly answer. It's difficult to say. And there are factors that cut in both directions. First, before 2021, OSHA had only issued 9 emergency temporary standards. This is an authority that they do not use very often. It's really only for emergency situations. And so they've only done it 9 times. 6 of those ETS were challenged in court, and only 1 was allowed to go into effect. So 5 out of the 6 have been invalidated by courts. That being said, all 6 of those challenges came in the 1970s and the early 1980s, the most recent being in 1983. So it has been a long time, almost 40 years since we had one of these challenges, but there is a history of courts invalidating ETS. On the other hand, the Supreme Court has already rejected challenges to state vaccine mandates in New York, Indiana, and most recently in Maine. And so the Supreme Court has already, some of the justices and the Supreme Court as a whole, in some instances, has already weighed in on vaccine mandates and has upheld those mandates. And the interesting thing there is many of those mandates did not include the test option that is available in the ETS, which certainly provides individuals with a little more flexibility. If they don't want to be vaccinated, they can still go with the test option. And so some legal experts have looked at it and thought that the ETS was more likely to be upheld than some of the state vaccination mandates that the Supreme Court has already upheld. And so certainly there are, I think, factors cutting in both directions here, and it will be fascinating to see first what the multi-district litigation panel does with these consolidated suits, and then what happens at the Supreme Court. I think this is very likely to get to the Supreme Court, likely very soon, because we have effective dates that are coming up relatively quickly. So I'll just finish by asking the question that I think a lot of businesses are asking: where does this leave businesses if the ETS are stayed and currently in litigation? Well, we are recommending to businesses, and I've seen a lot of others recommend, that businesses become familiar with the ETS and prepare to implement them. I think there's a good chance that the ETS will at least take effect for some time, or they also could be ultimately upheld. And I think businesses would be smart to know what's in the ETS and to prepare to implement those. Some businesses may choose, in fact, to implement them even if they're stayed or still undergoing litigation, in order to provide some stability, and if they think they're a good practice for their business. And so I think we're recommending that businesses learn what's in the ETS and take steps to prepare to implement the ETS, even though they're subject to litigation. And with that, I know we'll have some questions and we'll come back and visit those, but I'm going to turn the time over to Marie to talk to us about the intricacies of state OSHA plans.
Thanks, Ryan. And I agree. I think we're for sure going to see a lot of changes, but preparing now is going to be so important. And one of the reasons it can be particularly confusing for some businesses is because of the difference between federal OSHA and state OSHA plans. A lot of employers will ask, why do we even have state OSHA plans? The answer is a little bit historical. Some states already had their own workforce protections in place when OSHA went into effect in 1970. Also, if you have a state OSHA plan, it will cover public sector employees, which federal OSHA does not do. Federal OSHA only covers private sector employees. And then we have the whole laboratory of states opportunity that this gives us, where different states can try different things. And we've seen some states really lead out in this space. California is a great example. They have a lot of protections in place that other states and federal OSHA don't have. Oregon, some Some people say it's easiest to know what Oregon doesn't protect as opposed to what they do protect, because the list of what they do protect is so long. Washington is another state that really leads out in their state OSHA plans. Sort of a surprise mover in the pandemic was Virginia. Virginia was the first state OSHA plan to have a permanent COVID-19 standard put into place. So we're talking about emergency standards today. Virginia put a permanent COVID standard in place. And then there's cost sharing. So, in states that are governed by federal OSHA, OSHA has to bear all the cost of overseeing the program. In states that have their own plan, that cost is shared 50-50 between the state and federal OSHA. So there's a lot of reasons for why we have the different plans in place. But if we just look at the next slide really quickly, you can see which plans apply to you. So dark purple on this map, those are states that are governed by a state OSHA plan. Light gray are governed by Fed OSHA only. And if you look at the few that are a sort of a dark gray, almost black color, those are states that have the federal OSHA governing private sector employees, but they do have a state OSHA plan governing their public sector employees. So, and again, we'll send these slides out so you can examine it. I know some of the people on the call today have offices in multiple states, so you might be governed by multiple different OSHA plans. But at the end of the day, the most important thing to be aware of is that even if you're under a state OSHA plan, that state OSHA plan is required to be at least as effective as the federal plan. So if we look at the next slide, we're going to talk a little bit about what does that mean in the time of the ETS. So essentially, state plans, in order to be as effective as the federal plan, they have to act quickly. And so when the federal ETS comes out, they have 15 days to tell federal OSHA how they as a state plan to comply with the ETS. And then they have 30 days to actually issue their own compliant state ETS. And if they don't do that, they are falling out of compliance with the requirements of Fed OSHA. And so we actually saw this summer a sort of microcosm of what we're seeing now. And you might remember that this summer, there was a federal ETS issued governing healthcare workers and the vaccination of healthcare workers. And when that came out, there were 3 state plans in particular that pushed back. Arizona, Utah, and South Carolina all actively resisted implementing a state ETS that replicated or furthered what was done by the federal OSHA, and they all 3 have state plans. So because of that pushback, they actually received a letter from OSHA in October telling them that OSHA was considering revoking their state plan status and revoking their approval. So this is a really strong move by federal OSHA. We've never actually seen a state lose their state plan status except for once, and that was in a situation where Hawaii actually voluntarily gave it up because they couldn't meet some requirements, and then they later recertified. So we've never actually seen OSHA actively remove approval status from a state, but they sent this letter saying, like, this is what the next steps look like, and we're going to do it if you don't fall in line. So the states have now an opportunity to reply to that and to come into compliance, but if they don't, there is in fact a procedure in place that would allow federal OSHA to remove approval status for these states. And so we have to think about, if that happens, what does that mean for employers on the ground? So just if we could look at the next slide really quickly. If you want to look at what the actual revocation process is, if you're in one of these 3 states, it might be particularly interesting to you. When you get the slide deck, you can hit that header on there and it'll link out to it for you. But essentially, Fed OSHA first determines that the state plan is not as effective as the federal plan, which they have done in this initial letter. They have to inform the state of their intent to revoke, and there's some procedures that happen. The state now has the opportunity to respond. But if at the end of that process, they haven't issued a sufficient response, then federal OSHA would publish their intent to revoke in the Federal Register. And at that stage, there would be some notice and hearing procedures that would happen. And the practical impact of this is that to actually formally remove approval status for one of these states would take longer than the ETS is likely to be in effect. That being said, though, there are procedures in place where federal OSHA could resume concurrent jurisdiction with those states. And at the end of the day, the truth is that the states, in my opinion, are highly likely to remain non-compliant with Fed OSHA because the businesses in states that are governed by state plans, by and large, prefer to be governed by the state plan than by federal OSHA, because in most states, that means they have more control. They have, more sway with a state OSHA than they have with federal OSHA. And so businesses tend to move in the direction of wanting their state plan to retain its status. So if you're in a state that is maybe pushing back against Fed OSHA, if you're in a state where you're wondering, like, are they even going to issue an ETS in my state? You should, act as if your state is going to be compliant, because if they stay out of compliance, then federal OSHA might exercise its ability to come in and essentially remove the state OSHA's jurisdiction. So there's a lot more details to the procedures. I see that there's some questions in the chat about exactly how that happens. And yes, the states are required to notify Fed OSHA within 15 days of how they plan to comply. So the federal ETS came out on November 5th. 15 days from then, your state should be telling OSHA how it plans to comply. So again, you can follow that link if you want more details on this process. But at the end of the day, the state plan should be as protective as the federal plan. And that's sort of the be all and end all of what that outcome should be. And then of course the question is, okay, well, I know what governs me, whether it's federal or state OSHA. How do I know if the ETS covers me? And that's where we start talking about your employee headcount. So the easiest way to think about your employee headcount is if you have 100 employees anywhere, you're covered. So if you have 100 employees, but they're scattered across different offices, you're still covered. If some of them are hybrid, coming into the work site sometimes, but not always, some of them are fully remote, and some of them go into the office regularly, they all count. So any type of employee counts towards your 100 person head count. And if you hit 100 employees at any point while this federal ETS is in effect, the ETS governs you from that point forward, even if you later drop below 100 employees. So on November 5th, if you had 101 employees, it covers you. If on November 5th you had 90 employees, and sometime in the next month you get 10 additional workers, even if they're part-time or seasonal workers, and you hit 100, ETS covers you. So everybody counts, as long as they're an employee. Now keep in mind though, just because they count towards your head count doesn't mean that they will be governed by the requirement that they get vaccinated. So Adam's going to talk about that in more detail in a few minutes, but essentially everybody counts towards your head count, but who's actually governed by the policy is a little bit more nuanced. Who doesn't count towards your head count? Independent contractors do not count towards your head count, and staffing agency employees do not count towards your head count. They count towards the head count of the staffing agency, not of you as the staffing agency's client. If you have minor employees, they also count towards your head count. And if you have employees that are entirely outdoors for their work, doesn't matter, they still count as well. So everybody counts. Everybody in the US counts as an employee. And if you have, subsidiaries and franchises and things like that, the employees are, towards their actual employer. So if a franchisor has corporate employees, they count for the franchisor. If, the franchisee, the local restaurant, for example, has their employees and they count towards that franchisee's headcount. So that is how you determine if the rule covers you.
Let's jump in and talk about the written policy requirement under the ETS. So essentially the ETS gives companies two options of policies to implement. One, a company can require all their workforce be vaccinated, or you can give employees a choice, either to be fully vaccinated or to provide proof of regular testing and wear face covering. Importantly, the ETS does allow for there to be a mix of these two. So you can have a partial mandatory vaccine policy. So if a company has a set of workers that, for example, are interacting with customers a lot, and then another set of employees who are in a back office and don't necessarily interact with a lot of people, the employer can have a policy where that first set of workers are subject to a mandatory vaccine policy, while the second set of workers have the option of being fully vaccinated or getting tested and wearing face coverings. Regular testing, we'll talk a bit more about this in a minute. It typically means once a week with some exceptions, and we'll talk about that in a second. Also important is, what does fully vaccinated mean? So under the ETS, an employee is considered fully vaccinated 2 weeks after completing the primary vaccination. And the primary vaccination is, if it's, for example, Pfizer or Moderna, it's the 2 doses. If it's Johnson & Johnson, it's the 1 dose. Acceptable vaccines under the ETS include those approved or authorized for emergency use by the FDA, or those listed for emergency use by the WHO, or in certain limited circumstances, vaccines that are administered as part of a clinical trial in the US. The ETS does allow for mix and match, so meaning an employee that got the first dose of Pfizer and the second dose of Moderna would be considered fully vaccinated. Importantly, there's no exception for natural immunity. So if an employee has had COVID-19 and has antibodies, that doesn't matter. There's no exception in that circumstance. And if an employee has a mandatory vaccination policy, those employees would still need to be vaccinated. The written policy needs to be in place by December 5th. So it's coming up quickly there. But the vaccine and testing requirements don't kick in until January 4th. But the written policy needs to be in place by December 5th. The employer needs to make the policy readily accessible to all the employees through whatever normal methods of providing information to employees the company usually uses. And the policy needs to be drafted in easily understandable language. All right, let's move to the next slide and talk about that first option. So if an employer has a mandatory vaccination policy, what do you need to include in that written policy? Obviously, you want to make sure it's comprehensive and effective, and we'll talk about a lot of these bullet points in more detail here in a minute. But the first thing, obviously, you want to include is a requirement that the employees be fully vaccinated, and you would want to include the definition of fully vaccinated, which we just talked about. You would need to include exemptions for certain medical reasons, and those would be, for example, if a vaccine is medically contraindicated, is the term the ETS uses, and that just means that a healthcare provider determines that under the particular circumstances for this person that a vaccine is not appropriate. Another medical reason would be if there's a medical necessity that requires some delay in the vaccine. So the policy would need exemptions for those. You would also need exemptions for employees who are entitled to a reasonable accommodation under civil rights law because of a disability or a sincerely held religious belief or pregnancy. When you get the slide deck after the webinar, you'll be able to click a link there where it says reasonable accommodation. That will take you to a helpful web page of the EEOC where it helps employers determine how to evaluate an employee's request for a reasonable accommodation. But let's assume for a moment that an employee is entitled to a reasonable accommodation. What does that look like in the context of a vaccine mandate policy? So first, an employer could provide a reasonable accommodation by allowing an employee to work remotely if possible. And that might be the easiest and cost-effective reasonable accommodation if it's possible for that employee's job. An employer could also set up a workstation where the employee is socially distanced from other workers, or allow the worker or the employee to work a modified shift, or provide for COVID-19 testing. You should also include information on how vaccination status will be determined, how you're going to collect and store that information, which we'll talk about in more detail. You need to include the policy for paid time and sick leave for vaccination purposes, which we'll talk about. Make sure to set out any potential disciplinary action for employees who violate the mandatory vaccine policy. And for companies that have a mandatory vaccination policy, you may also obviously have some employees that aren't vaccinated because they are entitled to a reasonable accommodation, or they have a medical reason why they can't get the vaccine. That's a recognized exception to the policy. So for those employees, they're still going to be subject to the ETS's requirements for testing and face coverings. And so you will want to include those policies in your written policy as well. And so you would also want to include the procedure for notifying the employer of a positive COVID-19 test and the parameters for removal and return to work. That should all be included. All right, this next bullet point, I see we've gotten a lot of questions are, so who does the policy apply to? And obviously the big question is, does it apply to remote workers, and what are the nuances there? So the short answer is that employees who work exclusively remotely, exclusively from home, aren't subject to the mandatory vaccine and testing requirements, but that definition is pretty narrow. So if the employee comes into the office one day a month, they are going to be subject to the vaccine or testing requirement under the policy. Or, for example, if they're fully remote but meet with a client, the ETS is going to apply. I saw a question about in-person offsite. So if you have a fully remote workforce, but you have periodic in-person offsites, I haven't seen specific guidance from OSHA on this, but the ETS, I think, would almost certainly apply to those employees attending the in-person offsite. So you would need a vaccine mandate policy in effect or a testing policy in effect. And we'll talk a little bit more about the testing option here in a second. I think there was a question about if the workforce is almost all remote except for a small group of executives who come into an office. Those workers or employees who are coming into the office are going to be subject to the ETS's requirements. And then finally, you're just going to want to clearly communicate the procedures for complying with the policy. Okay, let's move on to the next slide. So what are the leave requirements? Companies have a lot of questions about this. So for purposes of vaccination, and I want to make sure we're making a distinction there between vaccination and testing. So this is for purposes of vaccination. An employer is required to first provide a reasonable amount of time to each employee during work hours for each of the primary vaccination doses, including up to 4 hours of paid time, and that includes travel time, at the employee's regular rate of pay. And then two, the employer has to provide reasonable time and paid sick leave to recover from vaccination side effects for each dose. And there are some distinctions between bullet point 1 and 2 I want to make here. So an employer cannot require employees to use personal or vacation or sick leave time that they've already accrued to get vaccinated. So you can't cut into any separate leave time that an employee has already accrued for vaccination. You're going to have to give some extra leave time for an employee to go get the vaccination. But for the second bullet point, for recovery time, employers can require an employee to use paid sick leave time that the employee has already accrued to recover from the side effects of the vaccination. Now, if an employee has not yet accrued enough paid sick leave for recovery time, the employer cannot require the employee to borrow from future sick leave. So you'll have to give some extra sick leave time for that. If an employee chooses to get vaccinated outside of work hours, the employer is not required to grant paid time for that, but you'll still have to grant paid sick leave and reasonable time to recover. So on that second bullet point, what does reasonable time to recover mean? Well, unfortunately, the ETS doesn't it doesn't specify the amount of time that an employer has to provide for recovery, but it does give some helpful guidance. So the OSHA says under the ETS that an employer can set a reasonable cap on the time that they allow for recovery, and that OSHA will presume that if an employer makes up to 2 days of paid sick leave available per primary vaccination dose, then the employer is going to be in compliance with this policy. So you have a safe harbor there, right? If you give 2 days for recovery time, you know that's going to be presumed reasonable by OSHA. Even if an employer does not have a vaccine mandate in place and their policy allows for testing, the employer still has to comply with these leave requirements for those employees that choose to get vaccinated. An employer is not required to reimburse for transportation costs to get vaccinated. So that's just an additional note there. All right, let's move to the next slide and talk about the testing option. So if an employer doesn't require vaccination, it has to ensure that employees who are not fully vaccinated comply with one of the following. So the first sub bullet point there is for employees who come into the office at least once every 7 days, so once a week, to a workplace where other people are present. Those employees have to be tested once every 7 days and have to provide documentation of the result to the employer within 7 days of providing the previous result. The next bullet point there for employees who aren't in the office every week. So if they don't report to the workplace during a period of 7 days or more, that person is going to have to be tested within 7 days prior returning to the workplace and must provide documentation upon return to work. So let's talk briefly about what does it mean where other people are present, right? So these requirements apply to workers who are coming into a workplace where other people are present. So that is broad, right? So if there's one coworker, this is going to apply. Or even if a worker comes to an office and interacts with, potentially a member of a cleaning crew, then that would also apply. And those employees would be subject to these requirements as well. And Adrian's going to talk more about this, but the employer is going to have to maintain proof of the test result. If the employee doesn't provide documentation of the test result, the employee can't return to the workplace until the result is provided. And an important note here, an employer does not have to pay for testing, right? That's different than vaccination, where the employer has to provide paid time for vaccination and recovery. But for testing, the employer doesn't have to pay for that time. They can, but they don't have to unless it's required by some other law or regulation or collective bargaining agreement. One other thing to note on this issue here, if an employee has a positive test result or has been diagnosed with COVID-19, the employer cannot require the employee to undergo testing for 90 days following the date of the positive test or diagnosis. So during that time frame, when they do return to work, they still have to wear face coverings, but you can't subject them to the testing requirement for that 90-day period. And employees that are not fully vaccinated are going to be subject to this testing requirement for as long as the ETS is in place. All right, let's move on to the next slide and talk about what's required for proof of vaccination. So whichever policy option a company chooses, right, if you have a mandatory vaccination policy or if you allow testing, the company still is going to need to know the vaccination status of its workforce, and it has an obligation to do that under the ETS. So acceptable proof of vaccination status include a shot record from a healthcare provider or pharmacy, a copy of the CDC's vaccination card, copy of medical records that show the vaccination, a copy of shot records from public health, state, or tribal immunization information system, or there's a catch-all here, which is just a copy of any other official documentation that contains the type of vaccine, the date of the vaccines, the name of the healthcare professional or clinic where the employee got the vaccine. And again, Adrian will talk more about this, but it's not an option for employees just to show proof. And this is a difference than from, for example, Cal OSHA. So an employer is required to maintain record of the vaccination status, and an employee can't just show proof, and that's not enough. Importantly, for companies that have already been collecting vaccination status through another form of attestation or proof, and you've retained records of that, you don't have to re-ascertain vaccination status through one of these appropriate forms listed here, so long as the employee's fully vaccinated status was documented prior to the effective date of the vaccination requirement, which is January 4th. Another big thing on companies' minds is, what's my potential liability if an employee submits false proof of vaccination? There's no requirement that employers monitor or detect fraud here. So that's not the employer's job. The employer is only going to face some kind of penalty or liability if it knowingly accepts fraudulent proof of vaccination and then maintains that proof as compliance with the ETS. So only in those very limited circumstances is a company going to have to worry about liability for fraudulent proof of vaccination. Okay, Let's move on to the next slide. So what about employees that say they've lost their vaccine card or they can't get documentation showing their vaccination status? So if an employee can't get the appropriate documentation, they can sign. There's a limited option that allows them to sign and date a statement that attests to all of the following things. So first, they have to attest to their vaccination status, whether it's full or partial. They have to state that they lost or were unable to produce proof of vaccination. If they can remember, they need to state the type of vaccine they received and the dates they received the vaccination. And they also need to include the name of the provider or clinic that administered the vaccine. And then they also have to include a declaration that the statement is true and accurate and acknowledge that knowingly providing false information may subject employees to criminal penalties. So one important thing to note here, before an employee is allowed to self-attest, they have to make an honest effort to get acceptable documentation under the ETS. And if an employee doesn't provide one of the acceptable forms of proof of vaccination status, an employer is going to need to treat them as not fully vaccinated. All right, I know we're throwing a lot of information at you here. There is a lot of information in the ETS that companies need to be aware of. And I'm going to turn the time over to Adrian now, who's going to talk about even more requirements under the ETS.
Thank you, Adam. So in addition to the big ticket item of a company having a policy that either requires vaccination or requires vaccination or weekly testing, there are other requirements as well that companies need to be thinking of to comply with the ETS. So one of those is an employer's response to a positive COVID-19 test or diagnosis of COVID-19. So regardless of an employee's vaccination status, if an employee receives a positive COVID-19 test or is diagnosed with COVID-19 from a licensed healthcare provider, the company has to require each employee to promptly notify them of that positive test result or diagnosis. And OSHA has indicated that promptly means notifying the company as soon as practicable before the employee reports to work that day. Also, if an employee is in the workplace when they receive this information of their positive test result or diagnosis, OSHA has indicated that it's sufficient to notify the employer as soon as safely possible while avoiding exposure to other individuals in the workplace. So this could mean the employee could return home and then notify the employer that they received a positive test result or were diagnosed with COVID-19. In addition, the company has to immediately remove that person from the workplace and keep them removed until they meet certain return to work requirements. So these return to work requirements are broader than the return to work requirements that the CDC currently has. So there are more options that allow employees to return back to work. So of these three, the first one is that the employee meets the return to work criteria in the CDC's isolation guidance. And that's typically a 10-day isolation period, and then employees can return to work after that isolation period. The second possible way to return to work is that the employee receives a recommendation to return to work from a licensed healthcare provider. And the third option is that employees receive a negative result on a COVID-19 nucleic acid amplification test, or an NAAT, following a positive result on a COVID-19 antigen test. And this allows employees who think they might have gotten a false positive on an antigen test to receive the confirmation testing from that NAAT. The CDC considers the NAAT to be the gold standard of clinical diagnosis of COVID-19, and so it has a higher sensitivity than antigen tests and allows employees who may have received a false positive to return to the workplace. It's worth noting that the CDC quarantine guidelines differ from what the ETS requires on this particular issue. So the ETS stops short of what the CDC recommends. The CDC recommends that a person in close contact, which is defined as within 6 feet for a period of 15 minutes or more within a 24-hour period, those individuals in close contact with someone with COVID-19 should quarantine for at least 10 days or 7 days if they're tested for COVID-19. The ETS does not have this requirement. So the ETS only requires that individuals who receive a positive COVID-19 test or are diagnosed with COVID-19 to be removed from the workforce, but not those who might have been in close contact with individuals with COVID-19. Companies are not required to provide any paid time off to employees who are removed from the workplace because of their COVID-19 status. And this is different than what we saw in Cal OSHA the Cal OSHA ETS requires that employees provide an exclusion pay to employees who are able to work but unable to do so because they have to be excluded from the workplace due to their COVID-19 status or exposure. And also, unlike what Cal OSHA requires, the ETS does not require companies conduct contact tracing or notify employees who may have been exposed to COVID-19 in the workplace. This doesn't mean companies are totally in the clear on this one. The ETS defers to state and local law on this point. So companies need to comply with the local and state law requirements on contact tracing and notification of employees. Okay, let's move ahead. The ETS also has face covering requirements. Employers have to ensure that each employee who is not vaccinated wears a face covering indoors and when occupying a vehicle with another person for work purposes. There are some limited exceptions to these requirements that we've seen in similar laws, such as when an employee is alone in a room with floor to ceiling walls and a closed door for a limited period while employees are eating or drinking, while wearing a respirator, or if the use of the face covering is infeasible or creates a greater hazard, such as when it's important to see the employee's nose or mouth for reasons related to their job duties. The employer also has to ensure that any face covering is worn by the employee and fully covers their nose and mouth, and it's replaced by the employee if it's wet, soiled, or damaged. Employers should not prohibit employees who desire to wear a face mask from doing so. And similarly, they should not prohibit customers who desire to wear a face mask, even if they're not required to because they're vaccinated. And unlike the Cal OSHA ETS, this ETS does not require companies pay for any costs associated with face coverings, but companies may be required to do so by other laws, or they could voluntarily provide face masks to employees if they choose to do so. The definition of face covering under the ETS is similar to other definitions that we've seen. It's just broadly a covering that covers the face and mouth completely, is made with 2 layers, is secured to the head, it fits snugly. So there's nothing extremely interesting about the face covering definition, but it's in here if you ever want to reference it. So in addition to face covering requirements, employers also have reporting duties. Employers have to report certain information to Cal OSHA. So companies have to report to Cal OSHA each work-related COVID-19 fatality within 8 hours of learning of that fatality, or report work-related inpatient hospitalizations within 24 hours of learning about those. In order to meet the reporting requirement, these events have to be work-related. OSHA has recognized that it's really hard for companies to determine whether an employee's COVID-19 illness is work-related, especially when employees might have been exposed inside and outside the workplace. But for purposes of the ETS, OSHA has said that when evaluating whether a fatality or inpatient hospitalization is a result of a work-related COVID-19 case, that they should follow OSHA's criteria in their record-keeping regulation. So companies can look to that to decide, if an employee is exposed to COVID-19, was it work-related or was it from exposure outside of the workplace? One of the unexpected and I think very interesting parts of the ETS is that the ETS requires employers to disclose certain information to employees in a pretty quick time period. So first, by the end of the next business day, employers have to provide anyone, either an employee or their written author or somebody having written authorized consent, that employee's COVID-19 vaccination documentation or COVID-19 test results. And this seems a little interesting because in theory, employees would already have provided this information to the company. So it's interesting they can then request it back. But OSHA indicated this requirement allows employees to have access to test results in situations where those test results go directly to the employer. Like if an employer has on-site testing, that result might go directly to the employer and employees can request that information. And I think one of the very curious provisions and potentially burdensome on companies is that employees or their authorized representatives can request from the company the aggregate number of fully vaccinated employees at a workplace and the total number of employees at the workplace. So that has to be provided to employees within 1 business day of the request. And in explaining the why behind this requirement, OSHA indicated that access to this information allows employees to evaluate the effectiveness of the employer's vaccine policy. And they could potentially then raise any concerns to OSHA and participate in the employer's vaccination process. Without this request option, the only enforcement mechanism for this would be OSHA inspections, which are pretty infrequent. OSHA does not dictate how this information could be requested from the company, so requesters could submit this request in any manner that provides adequate notice to the company, such as in writing, an email or letter, by phone, or in person. Also, employers are required to provide certain information to the Assistant Secretary of the DOL if they are requested to do so. So within 4 hours of a request, 4 business hours of a request, employers have to provide a copy of the employer's written policy and the aggregate number of vaccinated individuals and total individuals at the employer's workplace. 4 hours can be a pretty quick turnaround period. So employers need to have this written policy readily available and make sure that they're constantly updating their vaccine records. And also, by the end of the next business day after a request, all other records required by the ETS need to be provided to the Assistant Secretary of the DOL. Okay, the ETS also requires employers to provide certain information to employees. So let's move forward on the next slide. And this information has to be provided in a language and at a literacy level that employees understand. So companies have to provide the policies that are required by the ETS, the processes the company uses to collect vaccination status, what time and leave are available for vaccinations and to recover from side effects of vaccination, the procedures employees should follow if they have a positive COVID-19 test or are diagnosed with COVID-19, procedures to follow to request information from the company, procedures for COVID-19 testing, and face covering requirements. As you can see, this list gets really long and can be quite complicated. So that's why we always recommend that companies have a written plan that includes all of this information that they are required to provide to employees. This documents both to OSHA and to employees that all this information is available to employees. It's in one place, and the company can then ensure that it's understandable and readable for employees. Okay, on the next slide, companies are also required to provide information about the effectiveness of vaccines and provide a certain CDC document titled Key Things to Know About COVID-19 Vaccines. And this helps employees understand the benefits of being vaccinated and the safety of the COVID-19 vaccine. Also, employers have to notify employees about the OSHA regulations that relate to discrimination against employees. So there are OSHA regulations, several different ones pointed to on this slide, that prohibit employers from discharging, discriminating against employees for reporting work-related illnesses or for exercising any of the rights under the OSHA regulations. So if an employee requests the information from a company, such as how many employees are vaccinated and the total number of employees at the workplace, the company can't take any retaliation against that employee for exercising their right under the OSHA regulations. And also, companies have to provide employees notice that they could be subject to criminal penalties for knowingly supplying false documentation to the company. So the ETS doesn't specify how often this information has to be provided to employees, but it's sufficient that companies should continually notify employees as their policies and procedures change. And finally, employers have to keep certain records. So this includes a record of each employee's vaccination status and their acceptable proof of vaccination that Adam discussed. And also the company has to maintain a vaccination roster that has all of employees on it. So it has to include every employee at the company, indicate whether they're fully vaccinated, partially vaccinated, subject to a religious exemption, or they haven't submitted acceptable proof of their vaccination status. And this is something that that OSHA can request from companies. So they need to continually maintain and update this vaccine roster. And also companies have to keep employees' test results. They have to maintain vaccine proof and copies of test results. And these have to be maintained for the period of at least while the ETS is in effect. OSHA has given companies a slight reprieve by indicating these aren't subject to the 30-year employee medical record retention requirement, but they need to be maintained at least while the ETS is in effect. And these records are considered confidential employee records, so they should be maintained separately from an employee's personnel file. Okay, that wraps it up on some other requirements companies need to be thinking about for the ETS.
Thank you, Adrian. Great job. We have covered a lot of ground in the last hour. I was just looking at the questions. I think we have now answered 39. We're up 40 questions, and we will be sending out the questions and the answers to you. We've been trying to answer those as we go. I know we're working furiously to get the last few. I wanted to just thank each of our panelists today for all the work they put into this, preparing and also helping businesses with these types of issues. As I mentioned earlier, one of the ways that we've learned about the ETS is by building a document generation engine that helps businesses to create a policy that's ETS compliant. We also have return to work policies and Cal OSHA related policies. And if you think there's a way that we could help your business, feel free to take a look at what we offer at www.sixfifty.com/ETS. You can set up a free demo to see if our tools are something that could help you. In the time that we have left, it might be helpful for us to just answer a couple of questions live if we can. I'm just going to open up the questions here. Here's an interesting one. Do you have to keep vaccine records for fully remote workers? I have a guess at that, but I'll turn it over to the experts on that one. Is there an answer to that one? Fully remote workers, do you have to keep their vaccination status?
And I'm open to input from my colleagues, but I would say my reading of the ETS is that no, you would not, because they're not considered covered employees. So those remote employees count to getting you to 100 so that the rule covers your business, but they themselves would not be covered. But keep in mind, when you say remote, what do you mean? Because if they're coming in for anything, if they're going to offsite meetings, if they're meeting with clients at your client's place of business, they're not really remote, even though they're not coming to your work site.
Yeah, I think that's right. I noticed we also have just a question about the legal challenges. And we had an earlier question. What does it mean for the legal challenges to be stayed? Do businesses still have to comply? A stay essentially means that the ETS cannot take effect while the stay is in place. And so if that stay were to remain in place past the deadlines we talked about, those being December 5th and January 4th, companies wouldn't have to meet those deadlines. The thing that's difficult is that stay could be lifted at any time by the court, either lifted when it goes to the panel for multi-district litigation or lifted because the ETS are upheld on the merits. There's a chance in those types of situations that the deadlines could be extended, but that's one of the reasons we've suggested to businesses that they should take steps to comply because the stay that's currently in place could be lifted at any time. So we're just about at time. We want to thank you for joining us on our 650 webinar today. We've really appreciated the questions. It's been interactive and interesting. We hope that you'll join us on future webinars, and we hope that you'll check out our website, www.sixfifty.com, and specifically www.sixfifty.com/ETS if you're interested in our return to work site and specifically our ETS tools. With that, we'll sign off. We wish each of you a great day and good luck with navigating COVID-19, and we're grateful for all of the time that you put into the webinar today. So thank you to each of the panelists.